Let's just jump right in. Today, I'm putting on my hat as a senior forensic legal analyst, and we are going to conduct a clinical, methodical autopsy of what looks to be a massive institutional failure. We're breaking down the absolutely explosive testimony given by State Advocate Drushantha Ramsamy at the Madlanga Commission of Inquiry. We're going to look closely at this massive collision between official state prosecutorial standards and the severe internal administrative abuses she claims took place within IDAC, the Investigating Directorate Against Corruption.
So here's our official briefing structure for this explainer. We're going to systematically deconstruct this whistleblower's evidence layer by layer. We'll start with the direct accusations against former IDAC head advocate Andrea Johnson, then we'll move into Section 28, document fabrication, contaminated procedures, secret audio, the human toll on the witness stand, and finally, we'll map out all the contradictions.
Right. Just to ground us for a second, this all unfolded at the Madlanga Commission of Inquiry into Criminality, Political Interference, and Corruption. This was the stage where Advocate Ramsamy sat for days, literally methodically dismantling the official narrative of her own organization. Keep in mind, IDAC is supposed to be the elite unit hunting down corruption. So what happens when the unit itself is accused of operating outside the law? Well, let's see how this builds.
Section 1. The accusations against Andrea Johnson. We're looking directly at claims that the head of IDAC actively interfered in operational decisions, all while publicly denying it.
Do not tell him, let him go lying. Let that sink in for a moment. Ramsamy testified that during a January 2025 meeting, Advocate Johnson directed her team to deliberately withhold investigation details from the National Commissioner of Police. The alleged goal here? To let him walk straight into a perjury trap when he testified before the Parliamentary Portfolio Committee. This isn't just some casual water cooler comment. This is a direct allegation of a senior state advocate orchestrating a political trap instead of, actually conducting an objective investigation.
And this whole sequence really illustrates what Ramsamy called IDAC's line of march. Think about this timeline. On January 16th, Advocate Johnson emailed her team demanding a full briefing and a presentation on Operation Diversion. Then, at the January 22nd meeting, Johnson didn't just show up and listen. No, she brought a printed, manually edited version of Ramasamy's draft presentation with her own additions and subtractions scrawled on it. Ramsamy testified the explicit plan was to force Generals Kumalo and Masamola into an accused box. This completely 100% contradicts Advocate Johnson's earlier testimony where she flat-out denied direct involvement in drafting these presentations.
Moving on to Section 2, Section 28, Document Fabrication. We are moving from operational interference to hard, physical evidence of procedural contamination. And just remember, a Section 28 authorization is incredibly invasive. It basically allows investigators to compel evidence and testimony, almost like a massive subpoena.
Let's trace this May 2025 sequence carefully, because the timeline is exactly where the alleged fraud is exposed. In May, Johnson was aggressively pushing for these Section 28 authorizations. By May 27th, she actually instructs Ramsamy to just draft one giant umbrella authorization for all crime intelligence matters, seemingly to bypass individual case requirements. But the most alarming part? A Section 28 authorization for something called the Mukwege matter surfaces, completely signed and dated May 30th.
Now here is the absolute kicker. In July 2025, Ramsamy discovers that the Section 28 application for the Mukwege matter was drafted and submitted in her name. She literally went to a colleague's office and demanded, "Why is Mukwege in my name? I was on sick leave." Because as it turns out, Ramsamy didn't compile it at all. Let's be very clear about what this means. An official, highly invasive state investigation application was fraudulently attributed to a prosecutor who wasn't even at work that day, and the signature on it was allegedly backdated.
Section 3, Contaminated Procedures and Evidence. As a forensic analyst, this next layer of the autopsy is where you really start to see the complete breakdown of standard legal protocols. Okay, before an elite unit like IDAC can even launch an investigation, there absolutely has to be a foundational document, a Section 27 referral affidavit. But Ramsamy's testimony reveals a glaring, massive question. Why was this foundational document actively hidden?
Ramsamy paints a really bizarre picture of how evidence was handled. On December 5, 2024, Advocate Johnson calls Ramsamy into her office and pulls a highly sensitive Section 27 affidavit out of a gray document zip bag. Later on, when the accused persons in the Mukwege matter repeatedly requested to see this referral, just to understand why they were being investigated in the first place, it was withheld, kept totally hidden. Ramsamy suspects they simply didn't want to disclose it. On top of that, Johnson instructed that original police dockets be handed directly to her personal assistant, while the actual investigating prosecutors were only allowed to work from photocopies. That violently breaches objective evidence gathering and the basic constitutional rights of the accused.
Section 4. Secret Audio and Disclosures. The systemic breakdown of procedure we just talked about, well, it was mirrored by a complete, total breakdown of trust within IDAC's walls.
This comparison brilliantly illustrates the core conflict here. On one side, we have what we expect from the state, right? Transparency, fairness, objective law enforcement, open communication. But on the other side, you have the reality Ramsamy described under Johnson's leadership, extreme paranoia. We're talking paranoia to the point where Advocate Johnson instructed a project manager to secretly record an internal staff meeting in February just because she believed Ramsamy was speaking against her. Ramsamy straight up called it a reign of terror.
So, things reach a breaking point. Ramsamy testified she was made completely redundant for 9 straight months simply because she objected to instructions from Johnson and another investigator. When she finally found out her own boss was secretly recording her, she had had enough. She bypassed her own leadership entirely and initiated protected disclosures to the DPCI, the Hawks. And the truly stunning part of all this is the timing. Ramsamy was finalizing these protective disclosures right at the exact moment Advocate Johnson was sitting on the witness stand at the Madlanga Commission telling the public a completely different story.
Which brings us to Section 5, Demeanor and Bench Interventions. It's absolutely crucial to remember that behind all these dry legal documents and procedures are real people whose careers and mental well-being are literally on the line.
This is the exact moment the clinical facade cracked. Ramsamy stated, "Not only is Advocate Johnson deceiving the commission, she is throwing a junior under the bus. And now I am speaking from emotion." This wasn't just some standard professional disagreement. Ramsamy felt profoundly betrayed that her boss was allegedly lying under oath and using junior staff as human shields to cover up procedural fraud.
Driven by that sheer frustration, Ramsamy made a stunning demand on the official record. She didn't just allege the May 30th Section 28 signature was backdated. She actually demanded a forensic ink age analysis to scientifically prove it. The emotion of this moment was so intense that Chairperson Justice Madlanga had to gently intervene. He actually halted the proceedings to allow her to take her time and compose herself. It was just this incredibly raw display of the psychological toll that whistleblowing takes on a person.
Finally, Section 6, Revelations and Contradictions, Matrix. Let's pull all these forensic threads together and look at the big picture.
When we methodically compare the official claims against the whistleblower's counter-evidence, a really devastating picture emerges. While Johnson denied drafting presentations and claimed authorizations were totally lawful, the physical evidence, the edited hard copies, the forged signatures while Ramsamy was literally homesick, tells a completely different story. And the impact here, it isn't just bad PR for an agency. As an analyst, I can tell you this completely voids the legal standing of these investigations. Think about it. If the warrants are based on fabricated, backdated authorizations, then every single arrest that follows is legally poisoned. So, it all boils down to this. If an elite state body, designed specifically with extraordinary powers to root out corruption, is itself allegedly paralyzed by paranoia, fabricating documents, and running perjury traps, who is left to guard the guards? Advocate Ramsamy's testimony doesn't just damage IDAC, it sends massive shockwaves through the entire criminal justice system.